We mediate and arbitrate not on narrow questions and technical questions of law, but on grounds of equity for securing quick justice. In this age of globalization and free market, India's image is inextricably linked in the Committee of Nations with how quickly in international arbitration our courts can deliver justice. They're not interested in technicalities of law. In this connection, I'm reminded of the late Mr. Justice H.R. Khanna, one of the greatest judges of the Supreme Court, who said, and I quote, that it would be wrong to assume that judiciary in India can solve all disputes and all disagreements. Judiciary, after all, is one branch of the state. There are other branches. For example, the executive. The executive also has members. I'm giving a different perspective. Whether arbitration should be left to the realm of judiciary or we should think of another body, like the members of the executive. Members of the executive are trained magistrates. Arbitration is basically an exercise of quasi-judicial authority. They are not trained, they need not be trained in the narrow technicalities of law. If arbitration is left to the judiciary exclusively, it may harm the ultimate consumer of justice is the common man. The Arbitration and Conciliation Act of 1940, and then the Arbitration Act of 40 and arbitration, succeeded by Arbitration and Conciliation Act of 1996. One of the objects is that minimize court interference. What we have witnessed in the last 14 to 15 years is that the court interference is increasing. The common man is not getting justice without casting any aspersion on the brilliant judgments of our Supreme Court. We are getting a little confused all along. I'm glad Mr. R.K. Singh mentioned the ONGC case. The confusion in the ONGC case has arisen because the Supreme Court has said that any award based on arbitration can be challenged on the ground of public policy. And one of the ingredients of public policy is that it is against the substantive provisions of law. Public policy for the courts in England and America have been grappling with the definition of public policy for the last 150 years. They have not been able to define. The most exact definition of public policy, they say, it is an unruly horse. Sit astride, you never know where it will take you. Now, we can have any number of amendments, we can have any number of legislation. What is happening is a series of interpretations are being given by the highest court in the land, which is not enlightening us. I'll give just two examples. Till about 2005 or so, I'm not a practicing advocate, I am a former civil servant, it was said that the courts will nominate an arbitrator, but this will be an administrative function, section 11. In the sense that you nominate the arbitrator and let the arbitrator do his job. But then came a judgment in 2007 in Patel Engineering. They said, no, it's a judicial function. With respect, judicial function is that where the judge decides the rights and liabilities of parties. He takes evidence, here's the parties. But mere act of nominating an arbitrator, I wonder it can be described as a judicial act. The moment you say that this is exercise of judicial function, then institutional arbitration is out. And a former judge, there are certain limitations. The judges are trained in the technicalities of law. Members of the executive who are lifelong magistrates under the civil and criminal laws of land, CRPC, and various legislation, land, revenue, are not trained in the technicalities of law, but the substantive provisions of law. There is another Supreme Court hailed as a landmark judgment, I think in 2005, Ramnath International, where the Supreme Court said that if two parties, a division bench said, if two parties agree that in the execution of the contract there will be no damages, they forego the right to damages, even if the time is extended marginally. Well, the party that signs is bound by it. Fine, it's a good guideline for the arbitrators. But in 2007 comes a judgment of another division bench of the Supreme Court, which says no. If there is such an agreement, it will not be enforced. The courts will still have jurisdiction in spite of this. Now, these are two mutually contradictory judgments delivered by the Supreme Court in a matter of 3 to 4 years. It doesn't enlighten the common citizen whose right it is. Arbitration arose even in the 1940 Act, when it was discovered that the consumer of justice, the common man, if I can arbitrate on something, I have an option to go to a court of law also. There is no matter before an arbitrator which cannot be agitated in a court of law. But I choose the more expensive option. Why? Naturally, you have to pay the arbitrator. I don't have to pay the judge, but a consumer of justice has to pay the arbitrator. So if justice is getting delayed and the arbitrators and parties are subject to varying interpretations of the court, the entire purpose of the Arbitration and Conciliation Act of 1996 will be defeated. Secondly, I'm glad one of the topics is arbitration and mediation. The international experience tells us that mediation need not necessarily be done by the members of the judiciary. Even sovereign nations have challenged the jurisdiction of the International Court of Justice, say sovereign dispute, say if I'm not mistaken between Chile and Argentina. It was eventually resolved. One of the parties said no, we will not go by the narrow technical interpretation of the judges of the International Court of Justice. The Pope in Vatican was appointed the mediator, and he delivered a judgment, or an award, you might call it, a mediator's award, which was accepted by both the nations. So the point is, I place before this House whether an alternative model of arbitration should be evolved. Even now it is too late. Otherwise, my apprehension is we will be only developing a parallel judiciary which will be as time consuming, much more expensive. It will not help the ultimate consumer of justice, that is the litigant. Thank you so much.
May I ask one question? Excuse me. May I ask one question?
Please.
How does the
One second.
I will take not more than 1 minute.
Please.
How does the arbitration
act?
Yeah. How does the Arbitration Act or any other law for the time being in force ensure that the arbitrator is fair and impartial? In case either of the parties before the arbitrator feels that the justice has not been done to them, he will have the recourse to the court of law again.